The hearing will start now. This is Companies Finding Up 94 of 2023. Aaron Low Cheng Lee and another against Hodlnaut Pte Ltd. And originating application 451 of 2022, Hodlnaut Pte Ltd.
All right, thank you. Good afternoon. I'm giving my decision at this point. Parties, as before, I believe, let me just administer the Zoom elocution. So parties are reminded that there is to be no unauthorized photography or recording in any form, and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, I will be releasing a brief judgment, and I would emphasize that these are only my brief remarks conveying the main reasons underlying my decision, which I may add to in full grounds if needed. Now, I will skip over the introduction, background, and summary of arguments, and I'll proceed to the decision itself. So in the circumstances, and I thank parties for your respective submissions, I grant the application to wind up the company. I am satisfied that the requirements under IRDA have been met and the papers were indicated to be in order. The specific objections raised by the directors are not, to my mind, made out, and these concern, namely, whether the company is unable to pay its debts, whether the court's discretion should be exercised in favor of allowing restructuring to be attempted, and whether the judicial magistrates should be appointed as the company's liquidators. Taking the first issue, whether the company is unable to pay its debts, I do find that the company is indeed unable to pay its debts. Its obligation to pay cryptocurrency to its creditors counts as debts owed by the company and are relevant in determining whether the company is insolvent. The withdrawal halt imposed by the company does not alter that outcome. The application is made on the basis that the company is unable to pay its debts within the meaning of Section 1251E, read with 1252C of the same Act. There cannot be any argument that cash flow insolvency is a sole test under Section 1252C, and I cite the case of Sun Electric. The argument made by the directors is that the cryptocurrency holding should not be counted as debts owed by the company, referring to various provisions of IRDA. I find that the director's approach is flawed. Leaving aside for the moment these other provisions, the test of cash flow insolvency under Sun Electric is a broad one. The court considers whether the company's current assets exceed its current liabilities, such that all debts can be met as and when they fall due within the 12-month time frame so as to avoid absurd outcomes. It is important also to note that the Court of Appeal considered that time should be given for the realization of liquid assets and that contingent and prospective liabilities expressly stipulated in the statute. In my view, what this means is that the court should look at the holistic position of the company and consider not just liquidated claims, but also those that might be made on the non-monetary assets of the company, though which may ultimately be payable in money. And here the Sun Electric test has clearly been met. And judicial management, I note, was granted on the ground that the company was probably insolvent at the time, and since then the situation has in fact deteriorated. The reliance by the directors on various provisions in IRDA is with respect misguided. For instance, the directors argued that since indebtedness under Section 1252A of IRDA must involve fiat currency and cryptocurrency is not included in the definition of money under Section 2 of the Payment Services Act, and cash debts are not treated as movable property under Order 22 Rule 1.2 of the Rules of Court 2021, it follows that debts within the meaning of 1252C can only refer to liabilities denominated in fiat or actual money. Moreover, it's argued that 1252C provides that contingent prospective liabilities to be taken into account in determining whether the company is unable to pay its debts, with liability defined in Section 2 of IRDA as a liability to pay money or money's worth, and a claim in cryptocurrency is not a money claim. In my view, Section 1252A does not assist the director's interpretation of 1252C, as the former involves indebtedness measured by reference to a specific amount of money on a specific claim, in contrast to the more holistic approach on 1252C. 1252A specifies that demand made above $15,000, if not satisfied within 3 weeks, would be presumptive of the inability of the company to pay its debts and thus of insolvency. The fact that debts are to be defined in money or money's worth is not, I should think, a controversial point. But it did not follow that because debts are quantified in terms of value in currency, it is only when actual quantification of assets in monetary terms has been determined through concluded court proceedings that a debt arises. Holdings of these assets can be assessed by the court in a winding up petition. Whether or not the court accepts the valuation put on these by the applicant is dependent on the evidence before it. It's just a case of companies holding other kinds of assets, such as wine, precious metals, bought apes, or even tulips. And thus, the fact that the holdings were in cryptocurrency did not affect the outcome. This was just a particular kind of asset. Seen in that light, the difference between the present case and that of Algorand Foundation, cited by the directors, is apparent. In 3 arrows, winding up was sought on the basis of indebtedness under 1252A. The precise demand in question was apparently in cryptocurrency. That failed the requirement under 1252A as it was not a demand for money sum. I do not understand three errors to stand for the proposition that pursuing and obtaining judgment to obtain liquidated damages is necessary before the assessment is made of cash flow insolvency. That would, I think, be contrary to the guidance of the Court of Appeal in Sun Electric. For completeness, I should add that nothing by decision suggests that cryptocurrency should be treated as money in the general sense, a question which I did not have to decide in the present case. In this regard, the applicant's reference to the treatment of cryptocurrency in other jurisdictions is irrelevant to its treatment in ours, and in any event, I do not find that there has been any acceptance in any major commercial jurisdiction of cryptocurrency as being equivalent to a daily medium of exchange, which would call for similar treatment in Singapore. The imposition of the withdrawal halts. The directors relied as well on the fact that withdrawal halts of cryptocurrency were imposed by the company on the creditors as showing that there was no liability owed. Now, the fact that there may be a halt on withdrawal does not assist. A halt on withdrawal does not extinguish liability, nor does it necessarily postpone the accruing of liability for the purposes of cash flow insolvency. All it does is to prevent the withdrawal of the asset. It may be that there are appropriately drafted clauses that may effectively bar anyone holding an account subject to withdrawal halt from pursuing and winding up the company on the basis of an unsatisfied demand under 1252A, or even preclude them from establishing cash flow insolvency under 1252C. That I leave to the future ingenuity of solicitors. In the present case, though, I find that the withdrawal halt provisions do not have any such effect. Therefore, I find that the company is not able to pay its debts as when they fall due, having regard to its current assets and current liabilities, as argued for by the interim judicial managers. The value of the company's assets and those realizable within a 12-month time frame are insufficient to meet its present debts, and those which will fall due within the same period. No improvement through any increase in cryptocurrency prices would seem likely to bring the company out of its difficulties, given that net liabilities stand at about $92 million as of July 2023. Whether the court's discretion should be exercised against winding up, now this would depend on requirement to allow whether or not it should be exercised to allow restructuring to be pursued further would depend on requirements based on similar considerations to those for initial moratorium extension. But in addition, given that discretion is sought to be invoked in the face of a winding up application, the level of persuasiveness has to be ratcheted up significantly. I'm not satisfied that the grounds exist for winding up not to be ordered. The likelihood of any success in directors' proposed restructuring is, to my mind, very low. As pointed out by the judicial managers, the major creditors are not supportive. I will not deal at this time with the other issues that point against the proposed further restructuring or rehabilitation efforts. And while the directors have objected to the appointment of the present interim judicial managers liquidators, arguing on the basis of conflict, as the directors have alleged wrongdoing on the part of the interim judicial managers, I do not find that there was any reason to doubt the ability or suitability of the judicial managers to function as liquidators. Arguments were raised about the previous conduct of the interim judicial managers in relation to the failure to withdraw the assets of the company expeditiously before the failure of the crypto exchange FTX, and steps taken by the interim judicial managers that allegedly incurred substantial financial losses. And both of these points have been canvassed before the court previously and rejected. If anything, I'm satisfied that the familiarity of the company and its business would aid in the liquidation being more efficient, would be more efficient, sorry. I therefore appointed interim judicial managers as the liquidators of the company. In the circumstances, therefore, winding up is ordered with the following orders as well, that the IGMs are authorized to appoint solicitors at their capacity as liquidators, liberty to apply for approval of remuneration, and that the interim judicial managers are released from liability. I will also deal with the other applications. Mr. Leo, anything else I need to do at this time?
Your Honor, just one matter, which would be summons 4010, Your Honor. I would just be seeking leave to withdraw that summons because it was related to determining a question about the powers of an interim judicial manager. So, Your Honor, I'm seeking leave to withdraw that with no order as to cause.
All right. I assume no objections from anyone to that. Leave granted. Do I have your discharge application as well before me, Mr. Leo?
Yes, Your Honor. That would be summons 1537 of 2023, Your Honor.
All right. I should grant the discharge as well, I think. All right. Discharge so granted. Mr. Kang, Mr. Kwa, anything further at this time? Let me take Mr. Kang first.
No, Your Honor.
All right. Mr. Kang, nothing further. Mr. Kwa?
None, Your Honor.
All right. Thank you. All right. Thank you all for your assistance. The decision will be published as a brief judgment. Thank you all. Nothing further from anyone?
Your Honor, I'm sorry, Your Honor. I was wondering whether for good order, should OA 451 of 2022, which is the judicial management application, be dismissed as well, Your Honor?
Oh, yes, sorry. I think that follows as well. It's dismissed. All right. OS 451
Honor.
dismissed. No order to cause, I think.
Yes.
All right. No order. Anything else outstanding?
Nothing from me, Your Honor.
All right. Nothing from anyone? All right. Thank you all. Good
Thank
day.
you, Your Honor. Good day.
Good day, Your Honor.
Good day. Thank you. Court is adjourned.